Trace the growth and development of administrative law in England. England is regarded as the birthplace of the rule of law, and for a long time it was believed that administrative law had little or no place in the English legal system. However, with the growth of governmental functions, industrialization, and the emergence of the welfare state, administrative law developed rapidly in England. Today, it forms an important part of the English legal system and plays a significant role in controlling administrative authorities. The development of administrative law in England can be understood through its historical evolution from the period before the welfare state to the modern administrative state. Legal provision. The development of administrative law in England is largely based on the doctrine of rule of law, principles of natural justice, delegated legislation, administrative tribunals, Judicial Review Tribunals and Inquiries Act 1958, later replaced by subsequent legislation. Essential features or contents. The growth of administrative law in England may be studied under the following heads: position before the welfare state, Dicey's concept of rule of law, opposition to Droit, administrative growth of administrative agencies, development after the Industrial Revolution, welfare state and expansion of administrative powers, Tribunals and Inquiries Act, modern position in England. Position before the welfare state. Before the 19th century, England followed the concept of a police state or laissez-faire state, where governmental functions were limited mainly to maintaining law and order, defense, and revenue collection. Since the state performed very few functions, there was little need for specialized administrative agencies. Consequently, administrative law had a very limited scope and was not recognized as a separate branch of law. Dicey's concept of rule of law. The development of administrative law in England was initially hindered by the views of A.V. Dicey. Dicey strongly advocated the doctrine of rule of law, which means that every person, whether a private citizen or a government official, is subject to the ordinary law of the land and the jurisdiction of ordinary courts. According to Dicey, the existence of separate administrative courts or special legal rules for government officials would violate the principle of equality before the law. As a result, he opposed the recognition of administrative law as an independent legal system. Opposition to Droit administrative, under which disputes involving public officials were decided by special administrative courts rather than ordinary courts. He believed that such a system gave undue privileges to government officials and was inconsistent with the rule of law. Because of Dicey's influence, there was considerable opposition to the concept of administrative law in England during the 19th century. However, later developments demonstrated that specialized administrative mechanisms were necessary for efficient governance. Growth of administrative agencies. The expansion of governmental activities gradually led to the establishment of numerous administrative agencies, boards, commissions, and departments. These bodies were entrusted with functions relating to public health, education, transportation, labor welfare, housing, and economic regulation. As administrative agencies increased in number and importance, the need for the legal principles governing their powers and functions also increased. This marked the beginning of the practical growth of administrative law in England. Development after the Industrial Revolution. The Industrial Revolution brought significant economic and social changes. Rapid industrialization led to problems such as poor working conditions, urban congestion, labor disputes, public health concerns, and environmental issues. To address these challenges, the government was compelled to intervene in economic and social affairs. New administrative bodies were created to regulate industries, protect workers, and supervise public welfare measures. As a result, the scope of administrative action expanded substantially, leading to the further development of administrative law, welfare state, and expansion of administrative powers. The 20th century witnessed the emergence of the welfare state, under which the government assumed responsibility for promoting social and economic welfare. The state began providing services relating to education, public health, housing, employment, social security, consumer protection, and economic planning. The performance of these functions require extensive administrative machinery and board discretionary powers. Consequently, administrative law expanded rapidly to regulate and control the exercise of these powers. The growth of the welfare state is regarded as the most important factor responsible for the development of administrative law in England. Tribunals and Inquiries Act. The increasing number of administrative disputes led to the creation of administrative tribunals for specialized adjudication. The Franks Committee Report 1957 emphasized the principles of openness, fairness, and impartiality in administrative adjudication. Its recommendation resulted in the enactment of the Tribunals and Inquiries Act 1958. The act improved the functioning of administrative tribunals and strengthened procedural safeguards. It marked a significant milestone in the development of administrative law in England. Modern position in England. Today, administrative law is fully recognized as an essential branch of English law. Modern English administrative law encompasses judicial review of administrative action, delegated legislation, administrative tribunals, natural justice, legitimate expectation, procedural fairness, and control of administrative discretion. Courts actively supervise administrative authorities and ensure that governmental powers are exercised lawfully, reasonably, and fairly. Thus, despite Dicey's initial opposition, administrative law has become an indispensable part of the English legal system. Council of Civil Service Union versus Minister for the Civil Services, 1985. The House of Lords recognized judicial review on grounds of illegality, irrationality, and procedural impropriety, making it a landmark decision in English administrative law. Ridge versus Baldwin, 1964. The House of Lords reaffirmed the importance of natural justice and procedural fairness in administrative decision making. Importance or significance. The development of administrative law in England demonstrates how legal systems adapt to changing social economic conditions. It provides an effective framework for controlling administrative authorities while enabling the government to perform welfare functions efficiently. Modern administrative law ensures accountability, transparency, and protection of individual rights. Conclusion. The growth of administrative law in England has been gradual but remarkable. From a period when its existence was denied under Dicey's theory of rule of law, it has evolved into a comprehensive system governing administrative powers and protecting citizens against arbitrary action. The Industrial Revolution, the welfare state, administrative tribunals, and judicial review have all contributed significantly to its development. Today, administrative law occupies a central position in the English legal system.